Thank you very much. Thanks, Minister. And I see one member of the media here. There may be others, but I just wanted to make it clear right off the bat that this particular bill, because there would be public and media interest, would not apply to any case that may currently be, for example, the case of Supreme Court Justice Russell Brown. This particular bill would not apply. The current judicial disciplinary process applies in that case. Is that correct?
That's absolutely correct.
Okay, thank you. Minister, your consultation process for this bill was seemingly quite extensive, as you've described and Senator Delphine just speaked about, with respect to the legal community and judicial community, but you didn't consult with the federal ombudsperson for victims of crime, nor anyone else respecting the concerns of victims of crime. And given that the bulk of public outrage over conduct of judges has stemmed from mistreatment of victims of crime in some cases, it would seem that that perspective would be of obvious importance. And that was the impetus for my former caucus colleague, interim Conservative leader Rona Ambrose's bill on judicial training. So why did your government fail to consult with victims of crime or their representatives on a bill that could have a profound effect on their confidence in the justice system?
Thank you, Senator. That's a fair comment. I will state that at the outset, and we could have done better. The process was largely driven at the outset by judges themselves and the Canadian Judicial Council. That being said, since you first raised this point, and I'm glad that you did, we have reached out to the ombudsperson for the federal ombudsperson for victims of crime. And he has come back he's largely favorable to the initiative. He has come back with a number of smaller suggestions, and we will continue that dialogue with the federal ombudsperson, and I thank you for calling us out on that.
Okay, great. If you could perhaps provide those, I'm sure we may have him as a witness, but that would be helpful to us.
We certainly can.
Okay, thank you. And also, Minister, where's your gender-based analysis document for this bill? I couldn't locate it quickly earlier today, and given that the last GBA document that we reviewed from your department on Bill C-39, that document was kind of devastating to your case. So again, many of the cases that have generated public outrage about judicial disciplinary conduct that was worthy of disciplinary conduct have involved major mistreatment of women. It would seem that a gender-based analysis document could provide some valuable insight on that issue, and as senators, we should probably have this document before we question you so that we can get a better critique of that bill.
Okay. Thank you. I thought it had been provided. We will provide it. It has been done.
Okay, thank you. All right, and Minister Lametti, Bill C-9 does modernize the Judges Act, among other things, to improve the public's confidence in the judiciary. But while that modernization of the disciplinary process it was certainly necessary, it has to be said that, as we've talked about before, a very glaring problem facing our criminal justice system is court delays, and a significant problem about that, and one factor on which you, as the federal government, have complete control, is judicial appointments. And when I pressed you on this in October, you said that at that point there were 89 judicial vacancies across the country, and you indicated to me at that point that big improvements were coming. But at the beginning of March, there are still 86 judicial vacancies across the country. It's quite a shocking number. And as you know, Minister, the resulting court delays have led to very serious criminal charges getting thrown out of court. So that can really shake the confidence of Canadians in the judicial system. So, Minister, when will you make the appointment of judges a real key priority in doing your job?
Thank you, Senator, for that question. It is a key priority. I do work hard with my team to control the parts of the process that are within our control. And I can assure you that we deal with those parts very effectively and efficiently. I don't control all parts of the process, but I am pushing hard to make sure that those other parts of the process, which are there to ensure thoroughness and public participation through the judicial appointment committees, as well as other safeguards of the process, the police checks and that sort of thing, will move more quickly. I'm doing my best on that. There are a number in process right now, and will continue. I would point out, though, that the 95% of criminal cases in Canada are not heard by federally appointed judges. They're heard by provincially appointed judges, and I'm working with the provinces and territories as well to make sure that we can help move those processes along as well.
Great. right? Because as you're completely aware, then there are other parts of the justice system, family law court, civil courts, where Canadians are really being impacted by not having some of those judge vacancies filled, because their cases are then taking a very long time, whether it's a family law matter or an insurance matter or things like that as well.
I share that concern, Senator. Thank you.
Thank you. Okay, and Minister, I also want to ask you about the penalties that can be imposed under Bill C-9 in cases of judicial misconduct that do not meet the criteria for removal of a judge. So under your reformed process in this bill, there could be other penalties which could include expressions of concern, warnings, reprimands, forced apologies, training, education, or counseling. But C-9 does not propose an option to either suspend a judge temporarily or dock their pay. Were those types of proposed penalties that you did include in the bill, was that as a result of consultations? And what I'm wondering about is, you know, a forced apology, what possible benefit could there really be for that for either the judge or the complainant in a matter? And wouldn't you agree that perhaps a suspension or a monetary consequence might be a more appropriate remedy in certain circumstances?
Well, before turning it over to Patrick, first of all, with respect to monetary consequences, we have, you may recall, we have attacked part of that issue in a previous Budget Implementation Act, where we prevented the accumulation of pension benefits pending. And that was something that the judges felt very strongly needed to happen, and so we did that through the financial levers at our disposal. The general, I suppose, sense behind other penalties is that the panels will determine appropriate penalties for judges. It's really judges, I don't like using this as a verb, but policing themselves, and so it continues in that sense. My own experience in a variety of different spaces is that apologies can be very effective and profound for both the apologizer and the person to whom the apologies are directed. But there are other mechanisms that are envisaged here, and perhaps, Patrick, you would want to elaborate on that.
Mr. Xavier, who has been very helpful in the next hour. But with respect to the monetary consequence, I'm specifically, yes, I acknowledge that on the pension issue, that's good. But what I was wondering about is perhaps like a docking of pay or something like that. What would be your response about why that wasn't included as a possible remedy?
I would turn that to Patrick.
Thank you, Minister. So Senator, with respect to docking of pay, I mean, it's the idea behind the list of potential penalties that you find in Bill C-9 is that they're supposed to be consonant with a judge resuming their functions with the full confidence of the public. And if a judge has done something so severe that their pay needs to be docked, there was a general consensus in consultations, including from members of the judiciary, that we are probably in the realm of so serious that removal is warranted. I mean, it's the bar for misconduct and for judicial conduct generally is well, the bar for judicial conduct is very high. The Supreme Court has made that very, very clear, that judges really are expected to be a cut above in terms of how they conduct themselves, both inside and outside of the courtroom. And so if you're talking about something so serious that, yeah, the docking of pay is warranted, you're probably into the realm of removal. The idea was to create a list of sanctions that did not, you know, we had to strike a balance between a list of sanctions that could remedy appropriate misconduct and a list of sanctions that would go too far and, you know, allow for the imposition of sanctions instead of removal. We didn't want to create that incentive. We wanted to be sure that, you know, if that the list of sanctions appropriately reflected how high the bar for conduct is. And as for suspension,
on this, Mr. Xavier, in the second hour, this is a good chance to return to our dialogue with the minister, if we may.
If there's any time for a second round,
we'll aim for that.